So the estate planning has two basic or two ways to go, or main bases. Either it be a will-based estate plan or a trust-based estate plan. My preference, which I'm going to elaborate at the end of this discussion, is to do a mixture of a will plus trust, which makes the grantor, the creator, or the family member who's writing this estate plan or putting this estate plan into operation to benefit from the advantages of both a trust and a will, and try to minimize, probably not eliminate fully, or at least mitigate some of the disadvantages that come with a will or that come along with a trust. So as I mentioned, it's either a will or a trust based. Before that, I think most of us, when it comes to deciding to put a will or make a estate plan, there are two things that we should know that most people shy away from putting up in place an estate plan. And why is that? Most people either think they really don't have to put a will in place. They don't have really the big estate that should impose any reason on them to put a will in place. Or either they want to put a will. They have in their subconscious a desire to put a will, but they never do because they think that subconsciously they delay and delay and delay, and at the end of the day, it is to the detriment of the planner and to the family members eventually. That's most of why we don't think about, and I have to admit, I'm one of them. I haven't put my estate plan so far.
I can see the screen, so if you move
Okay.
it on the side.
All right. Okay. So I'm one of these people. Who I always think, well, I really don't have a big estate that I should put a will. I'm wrong. I'm definitely wrong. And I wouldn't advise you to follow my rules. I'm trying to maybe convince myself that I need to put a estate plan for myself and for everyone if they want a desire to go and start doing that. So let's move on to what is exactly a will. Almost everyone should have a will. Why should everyone have a will? Especially our community, our Muslim community. We should all have a will in order to put a plan for our assets to be distributed according. And I think most of you will share this with me, that we want to distribute the assets in accordance with the Sharia compliant plan or a Sharia compliant will. If we don't do that, if we don't have a will, we kind of die intestate. What does it mean intestate? Without a will? But what does this imply? This implies that the laws of the state where we are domiciled, where we reside, where we live, or where our assets are located, are going to be distributed in accordance with the laws of the state that have their own distribution metrics that would apply on our state if we die without a will. So what's a will? It's an essential part of it's a very important part of but it's basically your voice. This is your voice of the after a long time. After the person dies, this is the voice. You're no longer there to mandate who gets what. But your only option to do that is to put in place a will. And that's your voice that your heirs and the courts and everyone will hear your words, how you want your will to be distributed. If you don't put this will, you will die, and you will never, your desires and your intentions will never be upheld. So a will is your basically the voice of the decedent. And the good thing about a will that it is, you can always change it while you are alive. So don't think that you have put a will in place that you will not have the option to change it. You can always change it while you are alive and competent. So a will only be operative upon death. It does not necessarily never comes to play until you die. And as long as you're alive, you can change it. As long as you're competent, you can always write what is called a codicil to change your will. And why would you change your will? There are several things that can happen during your lifetime after you write your initial will, your first will. Things can happen. You can remarry, you can get divorced and remarry, you can have another kid, people can die who are named as a beneficiary or as a legatee in a will. These people can die, and you need to redistribute the assets, or you can have another baby. So you need to reallocate the assets amongst your kids after a new baby arrives. So you always have the option to change it. So it's not like you write it and you're stuck with it forever. That's not the purpose of a will.
Sam, do you want questions?
Yes, I can. I think it's better to have a kind of interactive. If that's, I'm willing to take questions. Yes. Yeah. All right. So let me give you an example about the fact that if someone dies without a will here in Maryland, and I think one of the hypothetical examples, if you can bring them yet, about Mr. Muhammad, the example that I used. If we have a will from Mr. Muhammad that's Sharia compliant versus a will from Mr. Muhammad that there is no will actually, where Mr. Muhammad dies intestate, and then the laws of the state of Maryland will apply to him or to his assets. So Mr. Muhammad dies, he has a spouse, he has 3 children, 2 boys and one daughter, and a mother. If Mr. Muhammad has like $200,000 in assets, and his children are over 21, all of them, and he has a mother. If under the Sharia law, the wife will get 1/8 of this $200,000, which is how much? 25,000. And the mother will get 1/6 of this Sharia compliant will, which is I think around 22. And then the rest will be
1/6 would be 33.
yeah, 23.
23.
Yeah. So this is according to the Sharia, this is mandatory. So we are talking here about 48, and then the rest will be distributed between the two sons and one daughter, split it on 5 and give 2 units of the remaining, of the residue of the Sharia compliant of the assets to one son. The other son gets also 2 units, and the daughter gets 1 unit of the residue, which is around 153 or 52. So that's the Sharia compliant will. But if he dies intestate, I know why spouses would probably like that, but the Maryland law specifies that the wife, if the children are minors, the wife gets half of the will, and the residue goes to the sons and daughters, the half, and the mother gets nothing. If the children are over 21, meaning they're adults, the wife still gets the half, in addition to additional allowance of $40,000. So we're talking here around 140 something, and then the remaining is split up among the children, and still the mother gets nothing. So that's a huge departure from the Sharia compliant will versus the intestacy laws. Almost all laws of all states are essentially provide the same kind of rules, more or less. Maybe you will find a family allowance or a mother, a spouse allowance in one state, an election for a spouse, maybe in New York, within the 1/3 avenue. So it really varies from state to another. But the good thing about having a will is that you can control that. So that's the basic role of a will is that you can control how your assets are distributed from your probate assets.
Brother, I have a question.
Yeah.
The 40,000 amount that you've listed, is it absolute or is it linked to the 200,000 example?
No, it's 43,000. She gets them in advance. Yes, absolute. And then the residue is split half-half.
Okay, so even if the state is, let's say, 300,000, it's still 40,000.
It's still 40,000.
So I have a question.
Yes. Yes.
So, two questions. So, I mean, just as a preparatory thing, can I make a general statement that if I die, I need my inheritance to be distributed via Sharia law, or do I have to specify these specific ratios at one time for this to be applicable?
So you can basically list what is the Sharia,
Or just
and
like
that's it, like a general rule, and that's it.
Yeah, just
You can do that, but I think it's advisable to at least share an appendix, which I do have. I try to share it with everyone for the Sharia, all the different scenarios. So the court, when it probates a will, it can also see who gets what, because at the end of the day, when the will is probated, there is a representative or an administrator who is appointed. Not necessarily the representative, not necessarily, because some of us don't have extended families here. So it could be a friend, it could be your lawyer who does that. So the lawyer needs some guidance. So it's always advisable to attach the table of the different scenarios for all Sharia, and it's available. It's not like something that is not all courts and all mosques and even banks in where I came from. I used to work. They have the scenarios available. You attach them, and whoever dies at the time of death, who's alive, gets the Sharia mandate distribution. You understand what I mean?
Yeah, definitely. And the second question, to piggyback off that is, so sometimes, for example, like you have a 401k and then you have to declare a beneficiary, for example. In those case scenarios, the will overrides what's in that?
No.
Okay.
No. So there's some cases where the will does not override. The will does not override the contractually transferred assets, like a 401k or a life insurance, or assets that are transferred by operation of law. So if you have a property that you own jointly with your spouse, like a joint tenants, by operation of law, that joint tenancy goes to the full property, or the whole property. The remaining goes to the surviving spouse. This is by operation of law. So the will does not override. That's why there is what is called probate assets. So probate assets, those assets who do not have a designated beneficiary, like a 401k or even a bank account. You can also put in a bank account, transfer upon death, or transfer ownership upon death to a designated person, or a joint account that's held with your wife that has an inherent clause there that the wife gets the remaining of the joint account upon any of the surviving spouses dies. All of this is outside the scope of the will.
Another question.
Yeah.
I know you covered the trust.
Mhm.
Does the trust override the joint tenancy or not? The trust.
Yeah.
Does it override the joint
Yes, it does, because in the trust, you transfer the right or the ownership of the property to the trustee. So the trustee is the owner of the trust. It's no longer you or your spouse. You go to the records and you provide a change of title to the trustee on the name of the trustee who's handling this trust, say trust of ABC. So the new owner of the trust is ABC. It's no longer a joint tenancy. And in the trust document, you can specify whatever you want in terms of distribution.
Sam, I have a question. If somebody is married to a non-Muslim, can they contest the will, like saying this is Sharia? In other words, in Maryland, does it have anti-Sharia laws?
Generally, yeah, well, it's a very tricky question, I have to admit. Disinheritance, most of the wills which are drafted in accordance with Sharia compliant will have to disinherit the non-Muslims or the rules that apply to our Sharia law, disinheritance, like someone kills someone, of course. This is actually even in common law. But generally speaking, disinheriting a wife can be invalidated, generally speaking. There are two categories that you cannot easily disinherit: the wife, the spouses, and the minor children.
But from a Islamic point of view, you can always give, if somebody has a non-Muslim wife, they can give them part of the estate.
Yes, you can. I mean, best way to do that is through a trust. Okay, so now we are. So does the will only? A quick question: does the will only kind of distribute the assets? No, it does have additional provisions that are very important to have, even if you plan to have a trust. Like you can nominate a guardian for your minor children, or if you have a disabled child or children, you can always mandate or specify who is a guardian for that child throughout his minority or obviously his disability. Also, you can also choose who gets to execute or administer your will after your death. So this will, as I told you at the beginning, there is an administrator that once the will gets probated by court, or like kind of a certified by the court, you have to appoint someone. You can also do that in the very beginning. On the will itself, you can nominate a person or persons, not only one. Finally, one of the things that you can also put in the will is your funeral arrangements, burial arrangements, which most of us would like to have in accordance with the Sharia law, obviously, and would like to have an Islamic center or an Islamic complex or Islamic specialized funeral provider to take care of this process. So the will is not necessarily for covering only the assets. It does have additional aspects to it. I know that I'm probably giving a hard time to follow. I'm trying to get some quick points to not to waste take the whole time. So these are the advantages. I want to very quickly go to the limitations of the will. One of the important issues of the limitations of the will, not necessarily here in Maryland, by the way, the probate process. The probate process is inherently lengthy and costly, especially if it's a big estate. Usually lawyers charge a percentage of the estate, and obviously the court charges higher if it's a bigger estate. And if it's a big estate and it's a contested estate and it's only a will, that's going to be taking forever. So the will does expose you to have a lengthy, costly, and public as well. You will have to publish the will. If you go to the Maryland court or Montgomery County court, and you have the will case number, you can also, there's a requirement that you publish the will. And you can look for that and know who gets what of your, everyone can know who gets what of your estate. So this is one of the disadvantages of the will, is that the fact that it is public and everyone, versus the trust, which we are going to tackle in a while. The trust is completely opposite. The trust is private. No one gets to see it. And obviously there is no probate process. So there is less cost.
Is it upon death or before?
Upon this. Once you start the probate process, one of the requirements is to probate it and publish it, because the creditors, you need to tell the creditors, whoever has any debt on the estate or a claim like a secured debt can come and collect before to provide the net estate. So that's one of the reasons why we publish it. It has, I think, every state is different, but it's 6 months if it's a big state that if someone claims. But if it's a small estate, it doesn't really necessitate even a publication. The small estate in Maryland is within $50,000 to $100,000 value.
And for big estates, what's the approximate legal fees?
Well, they can get up to 9%. It depends on the value. It's a percentage. So the higher the larger the estate, the higher the costs are associated.
So it's easily in our area, people can own a home of $1 million. We're talking about at least $90,000.
Yes, well, that's possible. In California, even it's higher, by the way. So we are one of the reasonable states here. So these are the limitations of the wills. Basically, what I wanted to mention, and then now we go to the trust-based. Again, the same reason why people think they don't really need to have a trust, because the trust is a very fancy word. Everybody thinks that, well, I have a trust because I'm really rich and I have a lot of assets and I really have to manage all these assets and properly distribute them, and there's principal, there is income generation, there's distribution of income, there's distribution of principal. All that is a very complex arrangement, or very complex arrangements that are not really for someone who has like one property or maybe two, a vacation house and a property and one car and a bank account. No, that's wrong. I mean, you have to put it in. You have to have a trust. A trust can always address any purpose. It can care for the disabled. You can have a special needs trust. If you have a special needs child, you can establish a special needs trust. You can also have a kind of qualified domestic trust, which is a very complex arrangement when you need to do, if you are a U.S. citizen married to a non-U.S. citizen, and your non-U.S. citizen will not get the unlimited marital deduction upon your death in terms of taxes, so you will need to put this money into the trust. Maybe she gets the citizenship later, try to, as a tool to defer taxes. So the trusts are very flexible tool where you can manage your tax arrangements for not for you only, but also for your spouse and children. So it's not only for the rich.
We don't owe taxes because we have a big
Excuse me?
taxes kick in only on federal state level, only when the state is more than several $1 million.
Yeah, you are right. It's $13 million now.
That's for the federal.
Yeah,
What
but
about the state?
let me tell you, the federal is going to come down to 50% this year. So the trend amongst the federal level or the state level is to reduce these exclusions. In Maryland, it's 5 million, but there is proposals to get it down to 2. So yes, it's currently accommodating for most of us. I think so. But I'm not sure about tomorrow. And that's why we plan, because we don't know what's going to happen tomorrow. So the trustee is the trust actually has 3 main players, which is you, the grantor, or the head of the household, usually, or the person who has the assets. It could be you and your spouse together, also the heads of the household. So it's not necessarily not necessarily referring to a father or a mother. The heads of the household, those who own the assets, are the grantors. And then there is a trustee, and that's a very important person, because this is the one who gets to own the assets, gets to manage the assets, and gets to manage them in accordance with your intentions, which are spelled out in the trust document. And then there are the beneficiaries, which are the third party, who are the beneficiaries. Usually they are the heirs, but they can be charities as well. If you wish to give a charity to a Muslim community, to the mosque, to a Muslim friend, to a Muslim cause, but these are always legal causes that can be also added to the purposes of the trust in terms of distribution. And you can also use the trust as a way to gift some assets to not necessarily Sharia compliant, with respect to your question. Yes, you can do that. The role of the trustee, yes.
If the grantor wants upon death to give some of his assets to a non-profit or religious organization, and it's exceeding the federal or state level, would this amount be exempt from taxes? Or still you have to pay the death tax?
Well, it will be exempt in terms of state tax, but there is also in Maryland there is inheritance tax. So the inheritance tax, you can look at it as kind of a transfer, and inheritance tax are exempt only for direct family members transfers.
So if it goes to a charitable, it will be
Charitable are always exempt, just a rule of thumb. So as I told you, the grantor is the person who creates the trustor or the testator. You are the one who writes the trust, put in all the terms and conditions. And the trustee is the one who manages. And one thing about the trustee, which is very important to know, the trustee acts in a kind of a fiduciary duty. A fiduciary duty, again, is a fancy word, but the real explanation, or the basic explanation of fiduciary duty, that the trustee does not act on his own. He cannot be self-interested. He has to act in the best interest of the beneficiaries mainly. So he's kind of someone who is distant from all that's going on. He's governed by the terms and conditions of the trust document. He enforces the trust terms and conditions. Usually you will see in any trust document the largest or the longest article, or the extensive provisions that define the powers and the rules of a trustee takes almost like maybe 40% of the document, because it has to spell out everything that the trustee can and cannot do. Of course, there are statutory obligations as well associated with that, which govern the manner in which he manages the trust. But at the end of the day, it's better to have it in writing, very clear, so that it doesn't create any confusion.
Who would oversee the trustee if they exceed their role?
Well, usually the trust documents specifies that, and usually if something is wrong with the trustee, there are provisions that specify how the trustee can be removed. Obviously, at the end of the day, that can always be done by the court. But we try to avoid going to the court because once we go to the court, things get very contested. So it's better to have a mechanism very clear about how to replace the trustee. Who gets the beneficiaries can also do that. The majority of the beneficiaries of the trustee can have a say, and they can put in place and implement a plan or a mechanism to remove a trustee if the trustee is not fulfilling his responsibilities, like he's not providing regular information, he's not managing the assets of the trust in a productive manner, he's not taking or is not keeping good records of the transactions, or basically he's not fulfilling the obligations, he's not distributing the income, he's not paying the claims, he's not paying the invoices. All of these are reasons for the beneficiaries can intervene before trying to go to court. Maybe you can specify like one beneficiary can have that right, two beneficiaries. You can specify a percentage who gets like the beneficiary can have 50% rights in the asset of the trust, and they have the right to remove them if they agree in writing to do that.
Does the grantor can be trustee?
Yes.
Trustee, it could be more than one person or just one person?
You can have co-trustees.
Or co-trustee?
Yes, and you can have a trustee, and you can have a successor trustee. You can have an alternate trustee. You can have a longer list of trustees. And we are going to tackle that hopefully at the end of the session about how to go through that. But you can always have all the list of potential co-trustees, maybe 3 trustees if you wish, but it's mindful, mind you, you have to keep it simple and working as well.
So the trust document is governed by the document itself.
Excuse me?
The document itself.
Yes.
You agree, that becomes the trust. Okay? So that can be modified.
Yeah, that's where we put all the assets and all the provisions.
But you say the agrees to be governed by the trust document.
Yes, that's the document that governs
So
how
that
the trust is run.
Can be modified.
Yes, it can be notified. There is a distinction. I'll get back, find 1 minute to that. Yes. So we have to distinguish between 2 types of trusts. The revocable trust and an irrevocable trust. A revocable trust to answer your question, is the one that can be modified. It can actually be terminated as long as the grantor is alive and competent. Remember, as long as anything that can be taken away, like a will or a revocable trust, can always be amended, changed, updated, revoked, terminated, as long as the grantor is alive and competent. If he is not alive, definitely not. If he's not competent, he has been declared non-competent, and usually declaring a grantor or a trustee, if the grantor is the trustee, there is also a mechanism in the trust document that says how the grantor can be declared incompetent. You can also specify that you need to get at least 2 medical opinions by 2 unrelated doctors, probably mental doctors, to specify, to attest that the trustee is no longer, does not have the mental capacity or competent to continue managing as a trustee the trust. Okay? So that's the distinction between whether you can change a revocable trust and there's an irrevocable trust as well. If you have an irrevocable trust, sadly you can never do anything about it. Once it's written, signed, notarized, you're stuck with it because the assets are no longer yours. The a revocable trust, you put the assets there, you sign it, you basically transfer them from the date of the transfer from the date of the trust document itself.
Why you make it a revocable trust if you cannot change it?
Excuse me?
Why you make the irrevocable trust if you cannot change it?
There are some better tax implications for an irrevocable trust for you, the grantor, and potentially for the children if you have a proper planning. So in terms of tax benefits, an irrevocable trust is more tax beneficial.
That would be visible for very large estates.
Yes, yes. It's always advisable to have a revocable trust if it's a reasonable estate. Yeah. You can also get some tax benefits from a revocable trust as well if you have the proper tax planning. But very rarely that small estates or medium estates would resort to a revocable trust unless there is a unless there is a need.
Another question.
Yes.
So the trustee, can it be an entity?
Yes, we are going to tackle that. Yes, it can.
If it is an entity, is it registered to a particular state, and the trustee, they decide to move to a different state, what happens?
It doesn't have to be registered as a trustee. There is no kind of thing called registered as a trustee. There are some financial institutions like banks, trust funds, credit unions, all of these financial investment advisory firms, investment management, asset management, all of this can have a branch or a function within them to manage the trust. If you want to change them, you can always change them. It's like hiring an insurance company to do to insure your car. If you don't like this insurance and you think they're not providing the good service and you're still the grantor and you're still alive and you're the trustee and you have the capability or at least the right to change the trustee, you can always do that and remove them.
Will it needs to be documented?
Yes, the trustee can be mentioned as someone specifically, or you can change it. But you always have to specify and document it. Yes.
How difficult is it to, let's say if you established a trust and then you want to sell the asset for some reason, do you have to dissolve the trust, and is it a long process?
No, it's easier because then, as I told you, the grantor is alive and he is a trustee. Once that, let me take back to explain. Establishing the trust itself is one thing, but funding the trust is another thing. So the trust is the box. You establish the box, but you have to put inside the box the properties. That's what we call the title change in the name of the trustee. You have to go to select the assets. If you want to put the property, like the initial question about the joint tenancy, you transfer the property into the name. This is into the name of the trustee, basically the trust. That's funding the asset. If you want to sell the asset, later on the trustee can sell it, can sign the transfer documents to the buyer, as long as the trustee is empowered to do that, which is usually the case. And then you can decide if you want to put the cash revenue that you receive from selling into the trust, or keep it away, as long as you have the power to do that. That's why the trust is a powerful document, as long as you are maintaining the trustee position in it, to decide what gets in and what gets out. You can always change it. You can always sell out of it. You can always put another additional asset, and you can always make these changes as addendums to the trust. So yes, you can sell it. It's like selling any property. You have the broker, you provide the title, and then go ahead and sell it.
Is this what is called living trust?
Yes, that's the living
Grantor
trust.
is the trustee.
Yes.
Until he dies, then it transfers
That's another name for a revocable trust, is the living trust, yes.
So if he dies, then transfer to the beneficiaries or?
Yeah, there are two things that you need to know when the grantor dies. Once the grantor dies, the trust, the revocable trust becomes irrevocable. Yeah, it's obvious because the grantor died. There's no one has the power to change it anymore. So it's a revocable trust. Irrevocable trust upon death.
If you have a couple, they are both grandchildren.
If you have a joint trust, yes, if you have a marital joint trust, and the one surviving spouse is still alive, she can continue managing the trust as a living trust.
And you have revoking it,
Hmm?
and revoking it, she can.
She can revoke it.
You have to report this tax report.
There will always be, obviously, some concerns in terms of tax handling of the process, because remember, there could be some interest that was already depending on the provisions of the trust. But yes, you can. Basically, yes, you can.
But the other beneficiaries do not have any right to, they have any right to?
The beneficiaries will only have vested rights, depending on the provisions of the trust. Yes, they have rights, but the rights are governed when they want to distribute their assets. You can include in the trust document that they get a principal at certain age. They don't necessarily get it immediately. You can specifically put in the trust some spendthrift clauses where you can control the way they manage by giving them only income. If you have an income generating property, for instance, and you don't want them to get this title to the property at the age of 19 or 17, you can always delay the transfer of the principal. After a certain age, it could be 21, it can be 25, it can be 30 even. You can also specify that they get the income only for a certain period. Or you can give them part of the principal if the principal can be divided. So yes, they have the right, and as I mentioned in the beginning, they also have some rights to remove a trustee by certain majorities.
But there could be a clause that when dissolved, it should be governed by Islamic law, distribution of assets.
Whatever you can do in a will, you can do in a trust. Whatever you can do in a will in terms of having an Islamic law, Islamic Sharia compliant will, you can have an Islamic Sharia compliant trust as well.
When the trust is fully dispersed to the beneficiaries, does it dissolve automatically?
Yeah, it will be an unfunded trust. There is no assets there. If you have a trust document, the best trust document drafted under the sun, and there is no funding, meaning there is no assets in the box, there's nothing there. It's a useless document. What does it do? It's already dissolved. De facto dissolution.
Well, if some of my beneficiaries put that money into it or something,
Beneficiaries would need to have their own trust. Once they receive the ownership of a property, they can establish a new trust. They don't need to really to go back to an old trust.
One question.
Mhm.
You have to produce tax report yearly for the entity or not?
Yes.
And basically the mortgage, how are you going to be?
The mortgage is paid out of, as I told you, the trustee manages the trust. Managing the trust is to collect their income and pay any claims as well, invoices, manages even the property itself. He can handle the renting, he can handle the maintenance.
And there are two separate tax reports, right? One for the grantor and one for the trustee, the tax report.
For as long as the grantor is alive, there is no tax report in behalf of the trust. It's only the grantor.
Only one.
Yeah. Once the trustee dies, the grantor dies, the grantor has to file an estate tax form, which is I believe 6706, and that's another scenario.
10 more minutes.
Okay. I think I answered most of the questions in terms of, I mean, or at least the presentation addresses some of these questions.
Yeah, I have one more question. So, is that a situation where the entity can be sued?
Which entity?
The trust entity?
Yes, it can be sued, yes. Yeah, it's an entity. At the end of the day, it's,
What happens in that situation?
the trustee has the obligation to defend it. Like if there's a property, I mean, it's a very hypothetical example, but if the property, which is part of the trust, the owner here is the trustee, and there is a negligence claim resulting from someone trespassing but was subjected to any issues while he trespassed. There's some common law protection even for trespassers, by the way. So if he gets hurt, he can sue the property owner. In this case, it's the trustee. So yes, the trustee has to defend against suits, definitely. Also, one of the things that the trust can provide is managing the assets on behalf of incapacitated children. So if you have one of your heirs disabled, the trustee can always do the management of the trust assets on his or her behalf for as long as possible. You can always specify that the trustee can get maintenance and support, like life support, rent, accommodation, food, education, transport, car, allowance. So that can also be specified in the trust document to serve for the needy, for the disabled. And one of the things again for the trust is you avoid the probate. There is no probate. If you have the trust there, you don't go to court. It's a private document. Trust takes care of it and distributes the assets in accordance with the provisions of the trust. One of the things that's very important also, and this is for someone wealthy, like you have assets in several states, like New York, Florida, here in Maryland. You will need to go, if you don't have a trust, you need to go to probate the assets. If these assets are probatable, for each state, each court, to the courts of each state. So you have to go to the New York courts, you have to do the orphans court here, you have to go to the Florida courts to do the probate for each asset separately, if you don't have a trust. But if you have a trust, you can always consolidate this process in one state. Why is that? Because you transfer the title in the name of the trustee. All these assets are consolidated in the hands and in the name of one owner, which is the trustee. Yes. Well, this is the best scenario, which I always prefer, is to have a trust and a will. The will, you get the benefits of the will, as we discussed in the beginning. You can have a will also, what is called a pour-over will. Pour-over will is the will that whatever is left over, like you drafted the trust, you put all the assets that you know that you have right now, but later on you forgot something. Or maybe you inherited assets somewhere back home in your home country, theoretically, and you forgot about them, or the process for bringing the assets here it's very difficult, and you want to pour over whatever is left, not included in the trust. You can have the pour over will to specify anything that's left over is going to be poured into the trust. So this inheritance that you forgot about, or you did not complete, or you did not really have the tools to transfer to the trust, or you didn't have the time, the will automatically carry forward all these assets and pour them, that's why it's called pour over, pour them into the trust. So they kind of get into the trust automatically by virtue of that will, with maintaining the benefits of the will and the benefits of the trust, and eliminating the disadvantages of each of them as much as you can. So that's usually the mixed thing, the mixed balance. Also, one of the things that I wanted to touch base that the will itself can be, that's another distinction for the trust. The will itself can establish a trust, which is called a testamentary trust. Testamentary trust is a trust that's specified in the will itself. So it does not get operative. You can have the trust ready, referred to in the will. Once the person dies, all the assets transfer automatically to the testamentary trust. Before that, there is no trust. As long as the person is alive and he has this arrangement, do you follow what I mean here? I think it's a little bit technical, but try to make it simple as much as possible. So the will specify that all my assets will go to the irrevocable trust, because it's irrevocable. Remember, the will, the person died, so it's an irrevocable trust. You cannot have a revocable trust for a deceased person. All the assets of my inheritance will automatically be transferred to this ABC trust. This is the testamentary trust. It's listed, mentioned in the will itself. You don't have to disclose. There is no disclosure here. You are basically referring to the trust, and you're putting everything in the trust document. You don't have to publish the trust document. You will only publish the will, which will only specify the name of the trust. But you don't have to publish the trust documents, the testamentary trust itself. That's one of the things. You don't have, it depends on the situation. You don't have to do all of that. I'm just trying to tell you what are the usual avenues or usual scenarios for arranging such a trust. Last thing is the trustee, and I think we came back to this question, having a corporation versus a person. As I told you, you can have both. You can have a person who manages the trust. It can be a family member, it can be the grantor, as we mentioned in the beginning, it can be one of the beneficiaries, it can be one of the heirs, friends, lawyer, or it can be a corporation. So what's the difference and what's the benefit? The difference is a corporation is more professional. They know what they're doing. You don't necessarily know what usually the selection for trustees, once you go down after the person dies, maybe the son, yes, I trust the son how he or she will manage, or the daughter will manage the trustee, but I don't really trust my friend. I don't have a friend even to trust. So I'd rather give it to a professional corporation or a professional entity to manage. They have the capabilities, they have the continuity, because of the trustee, not necessarily the grantor. Any trustee or a co-trustee or an alternate trustee can also just be unavailable or unwilling to take the role, and he can remove him or herself from the document, from managing the trust. This does not happen if you have a professional corporation doing that. There is a continuity plan, there is successors, there's a function that provides this on a continuous basis. But the fees are higher, but there are compliance as well. The benefit of having a personal trustee, one of the family members, is the awareness. Probably your son will know the family needs, will know that his daughter or his sister or his youngest son is not really capable of making any money these days because he's lost his job. So he can be understanding, not necessarily overriding, but understanding. You don't get that flexibility when you are dealing with a professional corporation. So but the fees are higher, but it offsets the disadvantages of having someone as a person. Does that make sense? Remember one thing that I wanted to conclude. The trustee does not have to manage the trust if, for instance, there is cash account, securities accounts, which are part of your trustee assets, trust assets. They don't have to manage it to maximize benefit. You just need to make it productive. So it's a very different standard. As long as it's productive, you can always, as a trustee, fulfill your obligations. So you cannot go and tell the trustee, you should have really invested in this stock because I think it should have made more money and all the forecast was. This is not something that you should expect from a trust. As long as he's putting in money, investing the funds in a producing asset, he has fulfilled his obligation. Fiduciary duty is key. Disinterest is key. Treating everyone equally and definitely managing to the benefit of the beneficiaries is one of the most important things to have as a trustee. I hope Ayat was able to navigate through the slides while I was talking. Do you have any questions? Anything is unclear?
You have business card?
Yes, Ayat has a business card, yes. My paralegal assistant, she's a lawyer, by the way, but she's in lawyers, not yet admitted here, but she's a lawyer by practice in Egypt.
In average, how long it takes the process to trust and assets?
Well, drafting the trust is drafting like any agreement. If you have your thoughts ready, it can take 1 to 2 weeks, meetings and discussion, and then the funding is usually quick. You always contact the records for the property. You go to the bank if you want to do that. I mean, it's not the trust is it's a complex document, but it's a streamlined one. You can finalize it in 2-3 weeks.
Thank you, sir. Thank you so much.
Thank you so much, and I hope this was informative and I answered your questions to the best of my abilities.